This video is the analysis of a contracts question. It is the contracts question which was used on the February 2001 bar exam. I assume that you are familiar with the facts of the question, so I won't repeat those to you. If you are not familiar with the facts, please stop the video, read the facts, and in fact, it would be an excellent idea if you analyze the question first, even if you wrote it completely first, and then use this video to check your analysis. In this question, Carter is the contractor and Owens is the homeowner. And Carter agreed with homeowner Owens to build a garage that looked like this: 30 feet wide, 25 feet in depth. There was to be a wall 4 feet from the rear of the garage to make storage space. So this was intended to be a storage space here. Let's put that here just to be clear. Carter built the wall 6 feet from the end of the garage rather than 4 feet, and that's one of the problems. The price of the contract for Carter's services was $8,500. The contract provided that the paint and the roofing shingles were to match the shingles which were on the home already. The contract provided that the work was to be completed by April the 30th. And the contract provided that time was of the essence. There are three problems with the performance of this contract. One is that the location of the wall, this mistake occurred. The wall was 6 feet rather than 4 feet from the end of the garage. Secondly, Carter did not finish on April 30th. Carter finished 10 days late, even though the contract provided time was of the essence. And finally, the shingles which Carter used did not perfectly match the shingles that were used on the rest of the house. They were close, and they were even higher quality than the shingles he was supposed to use, but they did not match perfectly, and the contract said the paint and the roof were to match. So these are the three problems. Now, you should practice law in the analysis of these questions as much as you can, rather than just viewing it as an isolated collection of problems. So put yourself into the position of the lawyer, and Carter comes to your office and says, I had this contract, I performed it, Owens won't pay. Please make Owens pay. What will you do for Carter? And the answer is, obviously, you would bring a suit against Owen, claiming that Owens had breached the contract, please pay up. Well, in your lawsuit over here, the analysis of your lawsuit is, first of all, that you must establish that a contract was formed between Carter and Owens. If you're suing someone for breach of contract, the very first part of your pleading has to be that the people had a contract. Well, in this case, there are no problems regarding that because the facts tell you that they had a contract. It was in writing. The statute of frauds doesn't even apply, so it doesn't even have to be in writing. So there are no problems with the formation of the contract. Secondly, we look for problems with the terms of the contract. Parole evidence rule, we don't have a problem where part of the contract is written and the oral part, someone wants to include an oral provision into the written contract, and the question is that oral provision going to be included or not? And the answer is that it depends on whether or not the parties intended for the writing to be the final and complete expression on the subject. Did they intend for the writing to be integrated? And if the parties intended for the writing to be integrated, then the oral expressions cannot be added. But we don't have any of those problems regarding the parole evidence rule. Ambiguity, ambiguous terms. We don't have any problems with an ambiguous term in this contract. Mistake. We don't have problems where someone wrote down something in the terms of the contract that's an actual mistake, and you have to deal with that. So we have none of these problems. We have a contract. We don't have any of these problems. We now look to changes in the contract. You recall that you can change a contract in two ways. You can change the people, or you can change the terms. If you change the people, you're looking at assignments of rights or delegation of duties or novation or revoking the rights of a third-party beneficiary. Those are all in your outlines. If you start with a two-party contract and one person assigns their rights to someone else, you now have a third person who was not originally in the contract. You change the people. If you had a contract and one party delegates their duties to someone else, you now have new people in the contract. If you have a contract between two people and there is a novation, you recall the novation is where both parties to the contract agree that some third person is going to completely replace one of the people in the contract. That's a novation. All three people have to agree to that. We don't have, and then finally, if you create a contract where there is a third-party beneficiary, remember, third-party beneficiaries are parties to the contract at the time the contract is formed. And so I form a contract with a Rolls-Royce dealer where I'm going to pay the Rolls-Royce dealer, and I tell the dealer to deliver the car to you because you're my good friend. Well, you are a third-party beneficiary. You are party to the contract at the time it was formed, whereas assignment of rights and delegations of duties are events which occur after the contract was formed. Now, if I form a contract with the Rolls-Royce dealer of the type that I just mentioned, and then 30 seconds after I say to the Rolls-Royce dealer, we've got a contract, deliver the car to you, and without anything else significant happening, I tell the dealer, I changed my mind. Don't deliver the car to you, deliver the car to somebody else or deliver it to me. Okay, so you were a part of that contract for 30 seconds, and now I tried to remove you from the contract. That's changing the people. This time I'm subtracting somebody from the contract. And can I do that? And the answer is I can do it so long as your rights have not yet vested, and there are rules about when your rights vest. So here, if we didn't change the people, and those are the four ways to change the people I just told you about. Those occur on about 15% of the bar exam questions. Next, you can change the terms of the contract. If you change the terms, this amounts to a modification of the contract. And in our case with Carter and Owens, we did not change people, and we did not modify the contract, change the terms. You can change the terms by modification or by waiver. We don't have either of those, so there's no issues here. You don't even need to include these in your analysis. You can if you want to, but you can just say nothing about them. But look out for them. Look for them. So now that we have formed a contract and we know what the terms are, we didn't change anything, the question is, you would now claim that Owens has breached the contract by not paying your client. A breach of contract is defined as the non-performance of a contract duty which has become absolute. When has the contract duty become absolute? And the answer is on the board here. A contract duty has been absolute when all three of these are satisfied. All conditions precedent to a person's duty to perform have either occurred or been excused. Time for performance has arrived with certain exceptions like anticipatory repudiation, and the duty has not been discharged. In your case, if you're representing Carter, you will say that the only condition precedent to Owen's duty to pay Carter is that Carter complete the project. And you will claim that Carter either completed the garage or the completion is excused by one of these excuses, which we will talk about more in just a moment. So you will say all conditions preceding to Owen's duty to pay Carter the $8,500 have either occurred or been excused. In your case, you're going to say excused, and you are going to claim that the condition is excused by substantial performance. We'll talk about the details of that in just a minute. Time for performance. You're talking about Owen's performance of paying the $8,500. Time to pay the $8,500 has arrived because when Carter has finished the work, it's time for Owens to pay. So the time has arrived and the duty has not been discharged. Now we're talking about Owen's duty to pay the $8,500. That duty has not been discharged. In your outlines, of course, you will see a number of ways in which a duty to perform a contract duty can be discharged. A contract duty can be discharged, for example, by the duty becoming impossible, by the duty has already been performed, so the duty, it's been discharged, you don't have to do it again. The duty has been discharged by modification because you can change the terms of a contract by modifying it. The duty can be discharged by accord and satisfaction. So look at that list of ways in which the duty can be discharged. Now please notice that this duty not discharged is actually a defense to breach, which that is the discharge of the duty is a defense which the defendant will raise. That is to say, if the plaintiff sues the defendant saying, defendant, you breached the contract because you didn't perform a certain duty, the defendant then may come forward and says, but my duty was discharged, I don't have to perform that. So claiming that the duty has been discharged is something that the defense raises. And you please notice here on the board that I have this listed as though, you know, it is a part of breach, but I put it here just because it keeps it simple, keeps the structure simple. But you have to keep in mind that it is the defendant who raises this issue that the duty has been discharged. In any event, the duty must not be discharged, no matter who has to prove it. I'm saying that the defendant would have to prove that duty has been discharged. But in any event, the duty ultimately must not be discharged. So this, regardless of who has to prove it, so this ends up as a part of breach, and it's easier to keep breach as having these three requirements, and just that's an easier way to think of it. So we're talking about Owen's duty to pay the $8,500. Owen's duty has not been discharged. So you would claim as the lawyer for Carter that Owens has breached by not paying the $8,500 because all three of these requirements have been satisfied. And finally, the remedy that you would seek are damages, which would be the $8,500, which Owens did not pay Carter. Now, when you bring this suit and you claim all these things, you claim that the contract, that the condition preceding to Owens' duty to pay has not occurred because we know that Carter did not perfectly perform the contract. But we are going to claim that Carter substantially performed, and that excuses the condition just as though, and when a condition is excused, you treat it just as though it has occurred. When there's been substantial performance, that also means that there was a minor breach. Because if I'm building a house for you, and I build a house and everything is perfect, except that one of the doors opens in the wrong way. The drawings said it opens clockwise, and I have it open counterclockwise, and it's an expensive house, and that's the only thing that doesn't comply with the specifications. Obviously, I have substantially performed. Now, of course, we need some factors to look at to decide whether or not there has been substantial performance, but in my hypothetical, everyone would agree that I have substantially performed the construction of this house, because the only thing that's wrong is this door that opens the wrong way. Well, if I then sue for payment, you will say, but Emerson, you did not perform. The specifications called for the house, for the door open one way and it's opening a different way. And so the conditions preceding to your duty to pay me have not occurred. But I will say the conditions preceding have been excused by substantial performance, because obviously what I did amounts to substantial performance. And now that I have substantially performed, you owe me. I mean, we treat that condition as though it has occurred because it's excused by substantial performance. But when you pay me, I have committed a minor breach. Okay? If I have only substantially performed, I have committed a minor breach. And if I've committed a minor breach, the deal is that you pay me the contract price, but you can withhold the amount of money that it takes for you to cure the minor breach, for you to hire somebody else to come and fix the door. So again, when I have only substantially performed, you must pay. You have to pay me the contract price minus what it takes for you to fix the minor breach. So if you are representing Carter and suing Owen, you will say that Carter breached because all conditions precede, pardon me, Owens breached, not Carter. Owens breached because Owens breach was the non-payment of the $8,500. All conditions preceding to Owens' duty to pay it did not occur, but they were excused, and you're going to claim substantial performance. Time for Owen to pay has arrived. Owens' duty to pay has not been discharged. So the problem really then is here. Owens will say, Carter will say, I substantially performed, and Owens will say, you did not. Now, if Carter did not substantially perform, did not even substantially perform, then in that case, Carter has committed a material breach. If I built this house, this hypothetical house that I was building for you a few minutes ago, and if I built half of the house and walked away from the job, that certainly is not substantial performance. Whatever substantial performance is, building you half a house is not substantial performance. So in that case, I have not even substantially performed when I built half the house and walked away. And now I would like to get paid for what I did. Well, in that case, if I want to get paid for what I did, I would sue for a quasi-contract. I can't sue on the contract because I am the breaching party, because I built half a house and walked away. But I can sue for what I've done. Quasi-contract, pay me for the value of the services that I have rendered. Some jurisdictions will not allow me to sue for on a quasi-contract theory if this is a willful or malicious breach. But if I breach for some reasons that are acceptable, and they're not, I didn't do it maliciously, then I can sue for a quasi-contract and I get the value of the services I've rendered. How do you determine the value of the services that I've rendered to you in the hypothetical that I gave you, where I built half the house? Well, the way you do that, let's suppose that I was to be paid $100,000 to build a house, and I built half a house and quit. And now I'm going to sue on a quasi-contract theory. Well, what you do is you get somebody else to finish building the house. And let's say the other person who you got to finish building the house charged you $75,000 to complete the house. Now, I was supposed to finish it for $100,000. I built half of it, but they for whatever reasons, cost $75,000 to finish. Well, what happens, in order for you to get the benefit of the bargain you made with me, obviously the way you want this to end up is that you pay the second contractor the $75,000, and then you pay me the $25,000. That way you got your house for $100,000. And that's the way you want it to end up. But the way you get there is important, and let me tell you how you get there. The way you get there is that I will sue you on a quasi-contract theory for the value of services rendered, you'll say, well, what are the value of, and you sue me for the value of services rendered. And so since this was a $100,000 construction project and I built half of it, I will say I'm suing you quasi-contract for what I did for you, and I want $50,000 for what I did for you. You say, fine, you will pay me the $50,000 for building half of the house. But you will also sue me for the breach of contract. And the breach of contract, where I didn't complete the house and you had to go out and get somebody else to finish it, well, if you pay me the $50,000 that I just sued you for a quasi-contract because I built half the house, and you pay the second contractor $75,000 for finishing the house, then you have spent altogether $50,000 plus $75,000, which is $125,000. Okay, and you spent the $125,000 because you paid me the $50,000 I sued for quasi and $75,000 to the second contractor. So you sue me for breach of contract, and the damages which you have incurred is the $25,000 extra that you would have to pay. You'd pay because you're supposed to get your house built for $100,000. It's now costing you $125,000. You sue me for the damages, and your damages are $25,000. And of course, the courts would subtract your $25,000 damages from the $50,000 that you were to pay me for building half the house, and therefore you pay me the $25,000. So you end up paying $75,000 to the second contractor and $25,000 to me, but you get there in the way I just described to you. This is a fairly common practice on the bar exam to have this kind of question. And the way it happens on the bar exam is that after I have built half of your house, something goes wrong. Now, I won't act maliciously, because if I act maliciously, I probably can't even sue you quasi-contract. But something goes wrong in a sense that something kind of innocent, like there's a strike, and all of my carpenters go on strike, and so I can't finish your house, or something of that sort, where it's a breach, but it's not something malicious. So I get partway through the contract, and for some reason I can't finish, and that's how all this happens. Now, getting back to our problem, Carter is suing Owens, and Carter is suing Owens, saying that Carter is saying I substantially performed, and our problem now is, did Carter really substantially perform? We need to know how to determine this. Before we go to determining whether or not Carter substantially performed, let's look quickly at these other excuses of condition. One excuse of condition has the broad title hindrance. Some people call this prevention. Some people refer to this as the implied promise to cooperate. In any event, if the defendant has hindered the plaintiff, then that will excuse the condition. I'm going to paint your house. I have a contract with you to paint your house. And I come to your house with buckets of paint and ready to go to work, and there's a fence around your yard, and there's this vicious dog there. And the dog won't let me in, and you know it, and you won't call the dog off, and ultimately I am prevented from painting your house. Well, if you prevent me from painting your house, then that excuses the condition. Remember, a condition preceding to your duty to pay me is that I paint. That's a constructive condition. It's a condition that the legal system puts in there. The condition preceding to your duty to constructive conditions are conditions that we didn't personally put into the contract, but the legal system puts the constructive condition in there. For example, if my performance to you is a condition on your performance to me. If we can both perform in an instant, then let's suppose, for example, I'm to buy your car, and we're going to do it on the street corner at 9 o'clock tomorrow morning. I show up at 9 o'clock tomorrow morning with money in hand, and you show up with the pink slip and keys in hand. Now, if we're both there ready to perform, but a condition precedent to my duty to, this is a constructive condition, the law puts this in there, we didn't have to put it in our contract. There's a constructive condition precedent to my duty to pay you, and that is that you deliver the car. And you say, but there's a constructive condition precedent to your duty to deliver the car, and that is that I pay you. So we stand there and look at each other, and I don't have to perform because you didn't deliver the car, and you don't have to perform because I haven't paid you. So we look at each other for a while and then walk away. Well, nobody is in breach of contract. And what you do is that if I want to put you in breach of contract, I tender the money. I can either offer to hand it to you or to a third party if I don't trust you. And so we don't trust each other. And so I tender the money, and if you then do not tender the keys and pink slip, you're in breach. If you tender the keys and pink slip and I don't tender the money, then I'm in breach. And again, if you don't trust each other, you can use a third party to accomplish that. And so these are called constructive conditions concurrent, where both performances can occur in an instant, and you end up with the situation I just described to you. Now, if on the other hand, if I am to paint your house, and we say nothing about do I paint first or do you pay first? Well, and not again, the law puts a condition in there. These are called constructive conditions because we didn't say anything about it, and the law puts it in there. And the law says that if we don't say anything about who performs first, that if my performance to you requires a substantial amount of time, and your performance to me, namely paying me, can happen in an instant, then the law says that I perform first. I paint first, and a constructive condition to your duty to pay me is that I have painted. So if I'm to build a house, I build first, you pay. Please notice, by the way, that this constructive condition that the legal system puts in there does not apply if we attempted to deal with the problem at all. If we said, for example, we made some statement about whether I paint first or you pay first, and the statement we made about it is ambiguous. Well, the legal system is limited to trying to figure out what our ambiguous statement means. It can't just throw it out and say, we'll use the constructive condition. So if we deal with it, the system has to figure out how we dealt with it. But if we don't deal with it at all, then the law puts the constructive condition in there and says, I paint first and then you pay. Now, getting back to hindrance here, there is a condition precedent, pardon me, there's an exclusive condition is that if you hinder, in my case where I went to your house to paint and you wouldn't let me paint because you wouldn't call off the dogs, you have interfered with my performance, and therefore that's an excuse. And so the condition precedent that I paint before you pay me is excused by your hindrance. And so the condition precedent has occurred, the time for performance has arrived. Well, it's arrived because I've finished painting now, because it's as though I've finished painting. So it's time for you to pay me. And when you don't pay me, that's your duty to pay me has not been discharged, and when you don't pay me, that's a breach. And so even though I've painted nothing, I've done nothing, I haven't painted your house at all, I sue for breach. And you say, okay, you will pay, but you don't pay the full price of my painting the house because of two reasons that you don't pay the full price for my painting the house. One reason is that when I sue you, all I'm going to get is my damages. Now, and what are my damages? Well, first of all, I have a duty to mitigate. And so I should go out and try to find some other work. And if I can, then that gets subtracted. So I have a duty to mitigate, and so I don't get the full price from you if I can mitigate some of my damages. And secondly, if I was only going to get a certain amount of profit, maybe this is the same thing, but if I'm only going to get a certain amount of profit because I was going to hire other people to come in and help me paint, and I was going to have more paint that I had to buy and so forth, and I haven't bought the extra paint yet. Well, whatever the extra paint was going to cost, I haven't bought it. I haven't hired the people who are going to work for me. And so you don't have to pay me all that because my damages don't include that stuff. So you just pay me the damages. Hindrance, then, is one way to excuse the condition. Waiver is another way to excuse the condition precedent. Waiver is the case where you waive a condition, you treat it as though it has occurred. For example, I am building a house for you, and the deal is that you will pay me when the architect signs off, saying that I've done what I was supposed to do. That's a condition precedent to your duty to pay me. The architect has signed off on it. Well, suppose you come out and look at the place and you say, gee, the place looks fine to me. I don't need the architect's certification. I'm waiving that. Well, you're waiving the architect's certification, and the condition precedent that the architect certify is excused by waiver. Can also be excused by impossibility. Now, suppose the architect dies, and the architect that was supposed to certify is dead. Well, it's impossible now, and so the exclusive condition, the condition may excuse by impossibility. Now, anticipatory repudiation is another way to excuse the condition. That is to say, if I tell you before time for performance, I am not going to perform when the time comes. Well, that's a present breach, as you well know, and that anticipatory repudiation means that if you the anticipatory repudiation excuses any conditions precedent to my duty to perform. In other words, if I was supposed to paint your house, and I tell you next week when I'm supposed to paint your house, I'm telling you now, I'm absolutely not going to paint your house. And so you go out and get somebody else to paint, and they cost more money, and you sue me for the difference. The condition precedent to my duty to paint your house, well, there were no conditions precedent, actually, in my hypothetical. But if we had some conditions precedent to my duty to paint your house, and I told you I'm not going to paint them even when the conditions precedent have occurred, then those conditions are all excused, and you can sue me now. You don't have to wait around. In our case, the question is, has Carter substantially performed? Well, there are basically two ways that you decide whether or not Carter has substantially performed. One way is that you ask the question, has Owen received the substantial benefit of Owen's bargain? Has Owen received the substantial benefit of the bargain? Well, that's kind of a very general question, and it's a question we want to answer, all right, but you can see how whether or not Owen has received the substantial benefit of the bargain doesn't give you a lot of tools to work with to decide that question. Sometimes it's perfectly obvious in the case where I built a house for you and it's an expensive house and one of the doors swings the wrong way, you have clearly received a substantial benefit of your bargain, and you don't need to go through a lot of complicated factors to try to figure it out. But if there's a close case, you need some factors to work with to try to decide whether or not there has been substantial performance. So the second way to determine whether or not there has been substantial performance, besides that generalized way I told you about, is under the restatement. Now, the restatement, section 241, lists these 6 factors, 1, 2, 3, 4, 5, 6, that can be used to help determine whether or not there has been substantial performance. These 6 factors are, number 1, to what extent has the plaintiff been deprived of the expectancy? In the case where I built a house with the door swinging the wrong way, you haven't been deprived of your expectancy very much. Will damages compensate for the plaintiff? Yes, because you can just hire somebody else to fix the door. If there has been some performance, how much? There's been some part performance. Obviously, in the case of the house I built with the door swinging the wrong way, I've almost 100% completed the job. So the part performance, a whole lot of it. The likelihood of cure. Well, if the person offers to fix it, but I suppose I told you I won't fix the door, so the likelihood of cure would be 0. Again, these are factors now. These are not requirements, so you don't have to prevail on every factor. Willfulness. Was the breach willful or not? If the breach was willful, and this should be an L, the willfulness of the breach is obviously a factor. And finally, the effect of the delay. That is to say, in the case of building your house, if to cure whatever it is it's going to take to cure the breach, that means that your house is going to get finished later than you had planned. How much is that delay, the time it takes to fix the breach, how much is that delay going to harm you? So these are the 6 factors, and I think these ought to be memorized, because if there's a contracts problem on the bar, it is so common to have something like this happen. So I would memorize these. In our case, Carter has built the garage, and there are some things wrong with the garage. And Carter says, I have substantially performed. Owen says, oh, no, you haven't. And so we need to go through these factors. Let's look at what happened here and go back to the lawsuit. Going back to our lawsuit here, Carter is suing Owens, and Owens is saying there was not substantial performance because the wall is located in the wrong place, you didn't finish by April the 30th, and the shingles don't perfectly match. Let's deal with each of those. First of all, the wall. The wall, as we know, is located 2 feet from the correct place. It's going to cost $800, according to the facts, to put the wall where it belongs. If you go through the factors, you will easily find that so far as the wall is concerned, the location of the wall, that Carter has substantially performed, and therefore, if there were nothing else wrong except the location of the wall, Owens would have to pay Carter. Owens would pay Carter $8,500 minus the $800 that it takes to cure the minor defect. Remember, when there's been substantial performance, there's always a minor breach, and it was $800 for it in this case. So if the wall were the only thing that's wrong, we would say that that is a minor breach. Carter has substantially performed. Don't forget, when you look at all 3 of these things, even though each of them might constitute a minor breach, well, you get enough minor breaches and you can say, well, maybe Carter hasn't substantially performed after all. So don't forget to consider all of the defects collectively, not just one at a time. Now, so the location of the wall we think is a minor breach. Second, and therefore this does not prevent substantial performance. Next comes April 30th. Carter finished 10 days late. And Carter finished 10 days late, and Owen says that's a material breach, not a minor breach. It's a material breach because I told you time was of the essence in this contract, and you finished 10 days late. Well, if time really is of the essence of the contract, and you don't finish on time, that is a material breach. However, you need to be careful because courts do not easily enforce these time is of the essence clauses. If you put a time is of the essence clause in your contract, the courts will enforce it only to the extent that time really is of the essence. Just saying it isn't going to do it. Time must really be of the essence, and even then, the courts will enforce the phrase only to the extent to which time was really of the essence. So these time, you can't just put that in all your contracts and expect it to be enforced. In this case, the contract said finished by April 30th and time is of the essence, but is time really of the essence? When you're building a garage in April, the summer is coming, and so you don't even have snow and that sort of stuff. Is there anything about this contract that really makes time of the essence? Not really. So the courts aren't going to enforce that provision. On the other hand, if I am to paint your house, and you tell me, you say, Emerson, you're finished by April the 30th, and on May the 1st, the next day, the movie company is going to come out here and make a movie, and they're using my house as part of the movie, and the painting job needs to be finished, the scaffolding removed, the place cleaned up, ready for the movie company. And so time really is of the essence in that case. And so it might be enforced, or at least enforced to the extent that time is really of the essence. But in our case, time is not of the essence, and the provision will not be enforced. Finally comes the roof, the paint and the roof must match the home. Well, the facts don't indicate that the painting didn't match. It's the roofing shingles. The shingles on the garage apparently don't match the shingles on the rest of the house. And Owens wanted it all to match up. And it would cost a lot of money, I think $2,200 to replace all the shingles. Well, that's a lot of money now for an $8,500 job. It's a fourth of the job. And so are we going to really make Carter replace all those shingles? Like we made him relocate the wall, are we going to make him rip off the shingles and put new shingles on? Well, this reminds us of those cases where someone put plastic plumbing inside of the walls of a new building instead of copper plumbing like the specs called for. And you're going to make the people tear out the walls, put the copper plumbing in there, and put the walls back. And the court says no. That amounts to economic waste, and we don't commit economic waste. Instead, what you do in that case is you look at the value of the house if the plumbing had been copper plumbing, as was called for in the specs, versus the value of the house with the plastic plumbing. And it's the difference in value of the house that the breaching party owes in that case. And so here, we would look at, the courts probably would not commit economic waste, and if this amounts to a breach, if what Carter did amounts to a breach, and we'll come back to that in just a minute, if it amounts to a breach, what's going to happen is that the court's going to look at, if you look at the value of this house with matching shingles, that is the shingles actually, if someone was going to buy this house and they came out and they looked at it and say, oh, how beautiful this house is, and they would say it's more beautiful if the shingles match, not quite as beautiful if the shingles almost match but not quite. Well, how much is that going to depreciate the value of the house? And that's the damages that would be used if you need to avoid economic waste. So the only remaining problem then is, was this really a breach when Carter used shingles that were close but not perfectly matched, and the quality was even higher than the originally intended shingles? And the answer is it depends on whether you're going to use fancy taste or you're using the functionality. If I ask you to do something for me and it calls from my personal, and it's something that paint my portrait, for example, and that calls for personal satisfaction. I mean, if I say to you, paint my portrait, paint my house, paint this room, whatever it is I want you to do, and if it's something that involves fancy taste, not mechanical functioning, and in that case, if I say paint it to my satisfaction, then you've got to paint to my personal satisfaction if that's part of our deal. But if I don't say do it to my personal satisfaction, remember, you got to actually agree to do, if you're doing something that involves fancy taste, it's got to be clear that you have to perform to my personal satisfaction, the color of the paint in the room and so forth. You got to do it to my personal satisfaction. And the reason that needs to be clear from the beginning is because it's such a heavy burden on the promisor to perform to my personal satisfaction that they need to really understand that that's the standard. Otherwise, a reasonable performance will do. Paint the room that's reasonably close to the color you ask, etc. Here, the shingles, it says the shingles are to match. Now, matching shingles, matching the appearance of your house is something that kind of calls for personal satisfaction. It's the appearance of things, not just that the shingles don't leak. So it's kind of an issue of personal satisfaction, but the parties did not specifically agree that this was to be done to the personal satisfaction of the owner. And if you don't specifically agree that it's going to be done to the personal satisfaction of the owner, then the deal is that you use industry standards. And so here then it's a question of whether or not the industry in this case would look at these shingles and say, yeah, those shingles match or they don't match. If those shingles match by the standards of the industry, close enough so the industry would call that matching, then Carter has performed to industry standards, because they didn't agree to personal satisfaction. There wasn't enough language in there to show that. If the industry standards are such that you would conclude that these shingles are not matching, if they are not matching, then Carter has breached. But again, the courts would probably not commit economic waste. They would make Carter would have to pay the damages, and the damages are the difference in value of the house with and without the shingles being better matched. That is the analysis of this question. That is the end of this lecture.